each element and about the combination of these elements. So it will come as no surprise to you when I say that there is a large body of case law that has grown up. By my count, there are at least 8 cases from the Supreme Court alone on this point, and many more from the High Courts, especially Delhi and Bombay. I would respectfully describe this line of authority, or well, lines of authority, as somewhat unsatisfactory. And I want to suggest that the reason it's unsatisfactory is mainly twofold. First, the courts have not always distinguished between questions of jurisdiction and questions of choice of law. And that, I would submit, is an important distinction. Implied exclusion is unambiguously a question of jurisdiction. The first topic which we heard about is unambiguously a question of choice of law. Now, there is overlap in the sense that the applicable law might be one factor to take into account in deciding whether the Indian court has jurisdiction, just as the chosen forum might be an indication of what law the parties intended to apply. But in each case, the question we are asking and the question we are answering is distinct. In the case of implied exclusion, we are asking, did the parties intend that the Indian court should exercise the largely supervisory powers which are conferred on it by Part 1 of the Indian Arbitration Act? The second reason it's unsatisfactory, and this is probably even more important than the first reason, is that the courts have not treated it as a question of construction, which is what I would argue it really is. In other words, in my submission, the question of implied exclusion amounts to asking, applying the modern approach to construction, which is closely associated with law of Hoffman, and which is good law in India. What did the parties actually intend that the Indian court should exercise the powers conferred on it by Part 1? The question is not to be answered by asking, did the parties conform to some independent rule of law which has certain ingredients, for example A, B, C and D, so that if they do A, B, C and D, Part 1 is excluded, but if they do only A, B and C, it's not. Now what I want to do in the next 8 or 10 minutes is to try and make good these two propositions, and to suggest to you that if these two propositions are right, then the mere designation of a foreign seat of arbitration will ordinarily lead to the conclusion that Part 1 has been impliedly excluded. Just to be absolutely clear, I am not saying that this is the current law. In fact, the better view as a matter of precedent, as a matter of what the cases actually say, is that the mere designation of a foreign seat is not enough. The point I am making is that if this matter goes to the Supreme Court, as it surely must sooner or later, and if the court has a large enough constitution to take another look at the cases, then the better view in principle is that interim measures apart, and I will come to that exception in a minute, the mere designation of a foreign seat is usually itself enough evidence that the parties did not intend the Indian court to supervise the arbitration. And I'll try and make good these two propositions by taking you through some of the cases on each of the 4 elements to the extent I have time. The first element is probably the least controversial and most straightforward. And the question is, what happens if the contract provides that it is governed by a foreign law? So in 2 early cases, Citation, Infowest and Intel Technical Services, the contract was governed by Californian and by English law respectively. When I say contract, I mean the main contract and not the arbitration agreement. It was argued by counsel in the Supreme Court that the Indian court nevertheless did not have the power to appoint an arbitrator, because when the parties say that their main contract is governed by Californian law or by English law, it must be taken that the parties did not intend the Indian court to exercise supervisory jurisdiction. Now the Supreme Court rejected that argument, and I would respectfully agree with the Supreme Court, because in my view, a choice of law is not ordinarily an implied choice of court. And this is true outside of arbitration as well. If, for example, you and I enter into a contract which provides that, and let's say we're not Indian companies, just to make the example more realistic. If we say in our contract that our contract is governed by Indian law and say nothing else, in my view, it does not follow that we have impliedly agreed to submit only to the jurisdiction of the Indian courts. I'm not saying it's conceptually impossible. We could agree to submit only to the jurisdiction of the Indian courts. But ordinarily, as the New South Wales Court of Appeal pointed out, a choice of law on its own is not enough. And so the starting point in the Supreme Court's analysis is one that I would agree with. But things get a little more complicated, or well, at least they're set to get a little more complicated. If the foreign law governs not the main contract, but the arbitration agreement, and in both Citation and Intel, there was no seat of arbitration, so the law governing the arbitration agreement would likely have been Californian or English. And the argument was that because the arbitration agreement is governed by foreign law, Part 1 of the Indian Arbitration Act is impliedly excluded. And this is why it's important to distinguish between jurisdiction and choice of law. The Supreme Court in Citation and Intel rejected that contention as well and said that the Indian court has jurisdiction. But this is in stark contrast to 2 later cases, Reliance and Union of India, and Videocon and Union of India. In both Reliance and Videocon, the law governing the arbitration agreement was English, the law governing the main contract was Indian, both expressly provided. And the seat of arbitration was Kuala Lumpur in one case, or Kuala Lumpur or London in one case, and London in the other case. In Reliance and Videocon, the Supreme Court held that Part 1 is impliedly excluded. Now compare these two pairs of cases. There is one difference, there are two differences and one similarity. In all four cases, the law governing the arbitration agreement is non-Indian. In two cases, that is Reliance and Videocon, the law governing the main contract is Indian. In citation and intent, the Supreme Court says Part 1 applies. In Reliance and Videocon, the Supreme Court says Part 1 does not apply. What is the relevant difference between these cases? It obviously cannot be the fact that the main contract was governed by Indian law, because even if that's relevant, and I don't think it is, but even if it is relevant, it would point the other way. It would point towards the Indian court exercising jurisdiction rather than declining it. So the difference must lie in the fact that the seat of arbitration was outside India in Reliance and in Videocon, but not in citation and intent. And as I'll argue in a minute, that's exactly right. And the principle must be that the question of which courts are to supervise arbitration must turn on the seat and not on the choice of law. But if you look at the actual reasoning of the case, and that's why, as David pointed out in relation to Suleiman, it's important to look at the reasoning and not just the result. The Supreme Court says in terms, in both Reliance and in Videocon, that the mere designation of a seat of arbitration is not enough to impliedly exclude Part 1. And so the proposition of law that emerges from these four cases taken together is the mere designation of a foreign seat or the mere designation of a foreign law governing the arbitration agreement is not enough. But the combination is enough. And I would respectfully argue that that reasoning is not easy to follow. And I think in principle, and I'll just cover very briefly because I am conscious that I'm really out of time. And the reason it's not easy to follow is that when the question is whether Part 1 has been impliedly excluded or not, we are not asking what law the parties intended the court would apply. We are asking which court the parties intended would supervise the arbitration. And it's relatively well established that the link to the supervisory court is established by the seat of arbitration and not by the governing law. And so that brings me to what I would say is the most important question in this area of the law, which is what is the significance of the seat of arbitration. And I'll briefly talk about that in concrete. As I say, in my view, the mere designation of a seat of arbitration is enough to exclude the applicability of Part 1. But this, I want to emphasize, is not the current law. Probably not the current law because it's not clear. Because in a case which I'm sure many are familiar with called Yograj Infrastructure and Sangyon, the seat of arbitration was Singapore. The law governing the main contract was Indian. The rules of arbitration chosen by the parties were the SIAC rules of 2007. Now, if my proposition is right, the mere designation of the foreign seat, Singapore in this case, should have led to the conclusion, subject to any special rule for interim measures, which we'll ignore for the moment, that Part 1 has been impliedly excluded. But the Supreme Court held that it was not the mere seat that led to implied exclusion. It was the fact that by choosing the SIAC rules, the parties impliedly sign up to the applicability of the Singapore International Arbitration Act 2002, because the SIAC rules, as they then were provided, that any arbitration governed by the SIAC rules would lead to the application of the Singapore International Arbitration Act. And so the proposition of law that seems to emerge from Yograj is that you exclude Part 1 of the Arbitration Act not by specifying only the seat, but by specifying the seat and by saying in terms or through the rules that the curial law shall be the law of the country, the seat of arbitration. And one might be permitted to respectfully question whether this is right, because ordinarily, the choice of seat is itself a choice of the law governing the conduct of the arbitration. I think in a recent case in the commercial court, Mr. Justice Hamlin puts this quite well, a case called Shagang and Daewoo Logistics, where the contract said that the arbitration shall be held in Hong Kong, English law to apply. It didn't say English law to apply to what? Should it govern the conduct of the arbitration or the arbitration agreement? Mr. Justice Hamlin, having construed venue as seat, said that the choice of seat normally carries with it the choice of governing procedure of the arbitration. And this is of course distinct from the question of choice of law. This is a question of jurisdiction. It's a question about which courts are entitled to set aside the arbitral award, which courts are entitled to appoint arbitrators, which courts are entitled to remove arbitrators, and so on. And so if the Supreme Court accepts, as it appears to do in Yograj, that the applicability of foreign curial law leads to implied exclusion, it seems to me to follow as a matter of logic that the mere designation of a foreign seat must also lead to implied exclusion, which is a proposition for which I would argue. Now, the practical importance of what I've said about both the law governing the arbitration agreement and the law of the seat is this. If the Supreme Court is right, it appears that on the one hand, Part 1 is impliedly excluded if the arbitration agreement is governed by foreign law. All of the QVL laws follow. And so in Reliance and Videocon, the foreign law governing the arbitration agreement was English and the seat of arbitration was London. But take a case where the seat of arbitration is London, but the law governing the arbitration agreement is Indian, and let's assume that's done expressly to avoid choice of law problems. I would argue that Part 1 of the Indian Arbitration Act is still impliedly excluded, notwithstanding the choice of Indian law to govern the arbitration agreement. But on the reasoning of the Supreme Court in Reliance and Videocon, the conclusion we would reach is the exact opposite. One point I should mention about seat. It is often said that the argument I've just outlined, that the mere designation of a seat of arbitration should be enough, is inconsistent with Bhatia itself. Because of course in Bhatia, the seat of arbitration was Paris, and yet Part 1 applied. But that's why I emphasized at the outset that this should be treated as a question of construction. Because if it is treated as a question of construction, when I say the mere designation of the seat is enough, what I mean is that the likely result of the process of construction is that the seat of arbitration will lead to implied exclusion. But it's always subject to some countervailing indication which shows what the actual intention of the parties was. And in Bhatia, the countervailing indication was that the parties had chosen the ICC rules. And I think it was Article 23 of the ICC rules provided that both parties could approach any court of competent jurisdiction for interim relief before or after the commencement of arbitration. Now what that means is that even though the seat of arbitration is outside India, the parties have agreed that courts of a country which is not the country of the seat of arbitration may grant interim measures. And so clearly it cannot be said that they intended to exclude all the provisions of Part 1. So unlike the first question in Bhatia, which is a question of statutory construction, the question of implied exclusion is not all or nothing. It does not follow that all of Part 1 applies or that none of Part 1 applies. And if a foreign seat is coupled with the parties having specifically provided for interim measures to apply, or even if there is no specific provision, it's perfectly consistent to say that the Indian court can exercise Section 9 powers but not Section 34 powers. So in conclusion, it's always dangerous to simplify it, but I think perhaps it's fair to say that the law on implied exclusion can be summarized in the form of 3 propositions. The first is, I would say, this is a question of construction, and the precise question of construction that we are asking is, did the parties intend that the supervisory powers of the Indian court should be exercised in this arbitration? So that distinguishes between jurisdiction and choice of law. We're not asking what law the parties intended to apply, we're asking which court should exercise whatever law the parties intended to apply. The second proposition is, the likely answer to that question is that a foreign seat is itself evidence that only the courts of the seat should exercise supervisory jurisdiction, and that's a relatively well-established proposition. The third proposition is that if the parties have expressly provided that interim measures may be granted, or even if they haven't expressly provided for it, it may be that it's not inconsistent to approach a court of competent jurisdiction for interim measures, but that does not entail that that court can also set aside the arbitral award or appoint arbitrators or remove arbitrators. I'm conscious I'm out of time, but that's really most of what I wanted to say. Thank you very much.